Excellence.
Your Excellencies, ladies and gentlemen, dear colleagues, it is my pleasure to welcome you to the resumed 473rd meeting of the Committee on Enforced Disappearances. I will turn the floor over to the head of delegation and the delegation that he is leading for 45 minutes to respond to the questions put to them. Your Excellency, you have the floor.
Thank you very much, Mr. Chair. I'd like to first begin with Ms. Janina's questions, and again, allow me to thank Mr. Chair and the distinguished delegates for your questions today. And we will answer each question with sincerity in order to have a constructive dialogue. Regarding the first question on consultations regarding our state report and the involvement of CSOs, I'd like to the second question on the draft law in establishing an organization and functioning of the National Human Rights Institution of Cambodia. I'd like to invite my colleague, Dr. Longsonita, to start off with these two questions.
Thank you, Your Excellency. Concerning the question raised by Ms. Janina on the involvement of the CSO regarding the productions of the report submitted to the Committee of Enforced Disappearance, while the consultation itself did not take place, but the productions of the report is under the working group of the Cambodian Human Rights Committee, and the Cambodian Human Rights Committee maintains its open doors policy to receive any invitations or any comments from relevant stakeholders, and that it also includes CSO. We also launch an app for the relevant stakeholders who are interested to submit their comments, as well as inputs related to issues concerning their interests. On the next questions concerning the establishments of the National Human Rights Institution, it's an independent body established by law in accordance with the Paris Principle, and it has been tasked to the Cambodian Human Rights Committee to draft the law, as Excellencies and Mr. Chairs and colleagues are aware of. There are 129 human rights institutions established worldwide, and among those, there are 5 in the ASEAN countries. And with the approval of our then Prime Ministers, the Cambodian Human Rights Institutions have been working on the drafting law of the establishment. The working group itself has already finalized the first draft, and it is comprised of 9 chapters and 32 articles. And to ensure the transparencies of establishing the drafting process, we have also co-hosted the consultation with the Office of the United Nations High Commissioners for Human Rights in Cambodia to co-chair the consultation process and to invite CSO to participate in providing inputs and comments on the draft law. It has been undergone 32 consultations nationally, regionally, and internationally with relevant stakeholders, including the ASEAN Intergovernmental Commissions on Human Rights, along with the National Institute of Human Rights in Malaysia, in Indonesia, and the Philippines, and the Asia Pacific Forum on National Institutions of Human Rights. Notably, it has also been circulated and received input from relevant stakeholders, including higher educations and academic institutions, as well as the bar associations of Cambodia and associations of persons with disability, women and children, and the press units, as well as representatives of indigenous people. Furthermore, it has also been posted publicly to receive comments from the general public should they be interested in providing inputs. Right now, It has been submitted to the Office of the Council of Ministers on the 19th of September last year, and it has also been consulted with the Council of Jurists within the Office of the Council of Ministers before awaiting further procedures. I now return the floor to Mr. Chair.
Thank you very much. Moving on to further questions, Ms. Janina raised whether there were any statistical information on any enforced disappearance cases within our courts, as well as what are the statistical information, how our statistical information gathered, and what is our system in gathering statistical information regarding cases in general, as well as enforcement disappearance cases. I will provide some answers on these, and then I'll pass the floor to my colleague. First of all, again, Cambodia does not have any enforced disappearance cases, so there is no statistical information regarding enforced disappearance under the definition of Article 2 of the Convention. Now, regarding how statistical information is gathered on cases, I pass to Excellency Sagarin, Secretary of State from the Ministry of Justice. Excuse me. Thank you.
Thank you, Mr. Okay. Yeah. Thank you, Mr. Chair. Very good afternoon, Excellent Chair, ladies and gentlemen. Regarding the question made by Ms. Chenia about the statistic, as the chairman has highlighted, in Cambodian we do not have the case of the case of the enforced disappearance. We have only a normal case, but how to gathering the data and information. Normally, under the Ministry of Justice, we have one department in charge to collect all the judgment sent by the court to the ministry. Ministry collect all this judgment and classify it to category. For example, murder, genocide, murder, violence. We categorize those infractions, and we have a statistic how many percentage of crime that committed felony or misdemeanor in different specific category of crime. So this is the process that we made, because we have also one department in charge of court management in assist to also to provide holistic infrastructure in order to assist the court on this. Thank you.
Thank you very much. Moving on to the next question regarding Article 31 and Article 32 and the declaration to accept these articles. The question was whether there was any obstacles to Cambodia in accepting these articles, and what is our consideration with respect to these articles in order to promote the combating of enforced disappearance. At the moment, as mentioned in our state report, we have not considered in accepting these articles yet. But the reason is that Cambodia will have to, the Cambodia Human Rights Committee will have to discuss. The simple reason is that the Cambodia Human Rights Committee has not discussed this with important and relevant stakeholders within both the Cambodian government and any other stakeholders that would be involved in the process. So in order to have a more concrete position on this, Cambodia would have to thoroughly study the acceptance of these articles, study these articles in comparison with its other obligations under various treaties and instruments, but also with other institutions like the Council of Ministers and the Ministry of Foreign Affairs and any other relevant government ministries and institutions. Moving on to the next question that we have here is whether there are any explicit provision to guarantee the non-derogation of guaranteeing that there will be no enforced disappearances, even during times of state of emergencies. To answer this concisely, there is no explicit provision that says there is no non-derogation beyond what is explicitly enshrined in the Constitution and what is mentioned in our state report, that we guarantee the right to liberty of Cambodian citizens. And to elaborate further on this, Cambodia has never declared a state of emergency as the state of emergency as defined under the Constitution. And regarding the law on the management of emergency, Cambodia has also never declared a state of emergency under this law, even during COVID times. I do want to highlight that within the law on state of emergency, during times of state of emergency, under Article 5, it states that when the country declares a state of emergency, the government has the rights to take the following actions. I won't read them all, but it will include restrict the freedom of travel, restrict the grouping of people, restricting certain business activities. However, if you go through this list, you will see that nothing allows the government, the state, to conduct any activities related to enforced disappearance. So, just to concisely summarize, beyond what is stated in the Constitution guaranteeing the Cambodians' right to liberty, there is no other provision. Nevertheless, within the provisions that allows derogation, there's nothing that says or it will even touches upon or relates to enforced disappearance. I'd like to move on to the next question is with regard to the extraordinary chambers in the courts of Cambodia and the cases of enforced disappearance here. Regarding the ECCC, the trial chamber as well as the Supreme Court chamber in the ECCC, first of all, I'd like to start off by saying that the ECCC law recognizes crimes against humanity and enforced disappearance committed as other inhumane acts. Now, the issue here was that the Supreme Court chamber in case 002/02 found that the elements of enforced disappearance did not exist during the time when the crimes of the Khmer Rouge were perpetrated, and specifically this is between 1975 to 1979. Nevertheless, what the Supreme Court examined was that what was provided by the civil parties, who are the victims that applied to become civil parties in the Khmer Rouge Tribunal, they found that what was provided in evidence, the testimonies, they all amounted to a level that is similar to a crime against humanity. So the court did find that Nguyen Chia, who is, Cambodians will often call him as brother number 2, the second most powerful Khmer Rouge leader after Pol Pot, who died before the ECCC began, and Khieu Samphan were both convicted of genocide, war crimes, and crimes against humanity, including crimes against humanity of other inhumane acts of enforced disappearance. And so this is related to the ECCC. Now, if you were to look at the lead co-lawyer's closing brief in the ECCC, you will see, I think the number, and we could provide this in detail for you later, was around 27 civil parties who have reported that there were cases of enforced disappearance committed towards their loved ones, their relatives. And this is all this information is to provide the committee because we believe that this will be useful and helpful for the committee to consider. But we do want to note that we understand that this was also before the ratification of the convention. Nevertheless, we believe that this information is helpful. Moving on to the next question on whether or not enforced disappearance is categorized as an autonomous offense within the laws of Cambodia. As we stated in our state report, as well as our reply to the list of issues, it is not considered as an autonomous offense. Nevertheless, we believe that it fulfills our obligations and commitment to enforce disappearance under Article 2 of the Convention because of the many other crimes that are listed within our criminal code. And to elaborate more on this, I'd like to pass the floor to my colleague, Excellency Kirin.
Thank you, Mr. Head of Delegation. So as we used to highlight in our report in 2021 and also in the reply 2023, Cambodia has a comprehensive legal framework and mechanism to ensure the effective implementation of the convention in terms of the definition of the infraction, its mitigation and aggravating circumstances for both in the formal situation and emergency one, as well as in the case of serious atrocity crimes such as crime against humanity, because we have a criminal code, criminal procedure to put forward to punish those crimes, and also to investigate, to conduct investigation, to prosecute, and also to have a fair trial as in accordance with the criminal civil procedure, criminal procedure code that is very comprehensive. And this is, as I would like to highlight, when we prepare this two code, we have been assisted by our foreign partner, especially from French. So this is what we have a comprehensive and legal framework and the mechanism to ensure effective implementation of the convention, especially to punish the offense. And therefore, Cambodian does not have or envisage any measure to incorporate enforced disappearance as an autonomous offense in our domestic law in accordance with definition provided in Article 2 of the Convention. However, when appropriate, Cambodia will consider and keep the committee informed and updated as we may from time to time to conduct a legal and judicial reform, including modernizing legal regulation to reflect the social economic development of our beloved country. We may cite paragraph 8 of the report 2021 as follows. Enforced disappearance is an offense against a person under criminal law provided for in Article 255 and 253 to 255 of the Criminal Code of all illegal arrest, detention, or confinement. And in Article 581 to Article 591, and abuse of power against you all. In addition, the law on suppression of human trafficking and sexual exploitation, and the law on prison, and the prison law also define offense and protect of all persons from enforced disappearance, as well as in paragraph 9 of the report 2021, the Kingdom of Cambodia, the widespread or systematic practice of enforced disappearance is considered a crime against humanity as defined in Article 188, as I highlight in our criminal code. And each of acts prescribed below, when committed within the framework of a generalized systematic attack carried out against civilians population, constitute a crime against humanity, murder, extermination, induction into slavery, forced deportation or transfer of the population, imprisonment, or any other form of deprivation of freedom in violation of the fundamental provision of the international laws, torture, rape, sexual slave, forced prostitution, forced pregnancy, forced sterilization, and all other forms of sexual violation of the crime seriousness, preservation of group or community under the political, racial, national, ethnic, cultural, religious, or sexual motivate, for disappearance, apartheid, and all other inhuman act that will cause a great sort of suffering or serious attack on the physical integrity. So this is what we can highlight to the committee on our legal framework and mechanism to prevent such crime. Thank you.
Thank you, Excellency. Just to further build upon that and elaborate, within our criminal codes, we have provisions, for example, regarding the abuse of power against individuals. This is Articles 588, 589, 590, and 591 of the Criminal Code. One of the core provisions that we believe fulfills our commitment to and our obligations in criminalizing enforced disappearance is also Article 253 regarding the arrest, detention, and unlawful confinement of arrest, detention, and unlawful confinement, that says that anyone without judicial authorization who unlawfully arrests will be punished by imprisonment. And depending on the circumstance, there are different sentencing punishments. Moving on to the next point, which this relates to, is mitigating and aggravating circumstances. And so within Cambodia's criminal code, yes, we do recognize mitigating and aggravating circumstances. I will now pass the floor to, again, my colleague from the Ministry of Justice, Excellency Gurin, to elaborate more on this.
Thank you, Excellency, Head of Delegate. As I highlight previous answer also about aggravation and mitigation, as I think I used to highlight a little bit early on this. So we have such an recognize of aggravation and mitigation on this. Thank you.
Thank you. And in addition to Excellency Gurin's statements on aggravating and mitigating circumstances, again, I do want to highlight that Article 96 of the Criminal Code states that in imposing penalties, the court shall take into account the seriousness and circumstances of the offense, the character of the accused, his or her psychological state, his or her means, expenses, and motives, as well as his or her behavior after the offense, especially towards the victim. This is on aggravating circumstances. And as I mentioned previously, one of the core provisions is Article 253 on the arrest, detention, and unlawful confinement. There is a provision on aggravating circumstance specific to this provision, which is the next article, Article 254, that states that if the arrest, detention, or unlawful confinement is accompanied by torture or acts of cruelty, followed by unintentional death of the person, or there's an attempt to secure a payment of ransom or a demand to fulfill a condition, the perpetrator is to be sentenced to 15 to 30 years in addition. Also, we have Chapter 2 of the Criminal Code that talks about general aggravating circumstances. And in addition to this, we also have a provision with regard to the mitigation or mitigating circumstances. And that is Article 93 and 94 that talks about the court's discretion in considering various factors in order to mitigate the circumstances of the sentence. Moving on to the next question, which is on the responsibility of superiors. I'd like to pass the floor to Excellency Gurin from the Ministry of Justice to elaborate on our legal framework regarding responsibility of superiors.
Thank you, His Excellency, Head of Delegation. Regarding to this question, I think the responsibility of superior is a kind of doctrine in a lot of court in the tribunal, international court for the international crime. And the ECC provide a lot of contribution to this in terms of superior. So regarding this, we refer to the report in 2021 and also the reply, our reply 2023. We would like to iterate that Cambodian will expressly incorporate into national law the criminal responsibility of superior as set out in Article 6.1.b of the Convention, when invoked discipline is incorporated as an autonomous offense into the domestic law, as we aforementioned. Furthermore, we may refer to Title 2 of Criminal Responsibility of Criminal Code, mentioning the responsibility of an instigator. This defines that an instigator of a felony or misdemeanor shall be a person who gave instruction or order to commit a felony or misdemeanor, to provoke the commission of a felony or misdemeanor by the means of gift, promise, threat, instigation, persuasion, or abuse of authority or power. An investigator may be punishable if a felony or misdemeanor was committed or attempt. An investigator of the felony or misdemeanor shall be incur the same penalty as the perpetrator. And also we refer to then Article 28 of the Criminal Code regarding an accomplice, and who shall be a person who is knowingly, by aiding or abetting, facilitating an attempt to commit a felony or a misdemeanor or its commission. An accomplice of the felony or misdemeanor shall be incurred in the same penalty as perpetrator. Article 29 of the Criminal Code. Thank you.
Thank you. Next, the question that I have here is with respect to offenses, enforced disappearance offenses, what will be the minimum and maximum sentences? I pass the floor on to my colleague.
Thank you, His Excellency, Head of Delegation. I think it very, as we has mentioned, that we don't have an invoked disappearance as an autonomous offense. So to reply, it's depend on the behavior. I mean the illegal acts that committed by the perpetrator, by a co-perpetrator, or by the accomplice, or by the instigator. It's depend on category. So we have depend on the category, what category of crime that they have committed. So we can have a lot of list of minimum and maximum as provided in the criminal code. So we can have, for example, if they committed and a kind of crime against humanity, so up to life sentence. If they commit as a kind of genocide, it can up to life sentence as well. And others, it depends on, as we highlight in our report, it depends whether which category of infraction. Thank you.
Yes, so because there's no autonomous offense of enforced disappearance within our criminal code, it'll be on a case-by-case basis of what the offense falls under Cambodia's criminal code, and so the minimum and maximum sentence will depend on, as Excellency Kidin mentioned, the category or the type of offense. I will now move on to the next question I have here, which is regarding the statute of limitation, and when does the statute of limitation commence under Cambodian law? I'd like to pass this to my colleague, Excellency Gideon.
Thank you, His Excellency, Head of Delegation. I think in regarding this issue, we used to highlight in our report and also in the replies, the term of the statute of limitation for criminal proceeding with respect of felony or misdemeanor and petty offense commenced at the time of the offense was committed. So the statute of limitation is interrupted by the accusation or the investigation. And the end of the accusation or investigation can be restart the new period of the statute of limitation. So the new period apply to everyone involved in the case based on Article 11 of the Criminal Procedure Code. This article is applicable to the case of enforced disappearance. Thank you.
Thank you. Yes. So as we mentioned in our state report, Article 10 states that for a felony, the statute of limitation runs 15 years, a misdemeanor 5 years, and a petty offense is 1 year. And as Excellency Kurin mentioned, Article 11 allows for the interruption of the statute of limitations. We understand that it is the committee's concern that because of the continuous nature of enforced disappearance offenses or crimes, that the concern is that the statute of limitations would run out. Nevertheless, as Excellency Kurin mentioned, Article 11 allows for the interruption of the statute of limitations when there is an accusation or an investigation. And as a result, Article 11 states that the end of an accusation or investigation can then restart a new period of statute of limitations. So what that means is if there is an ongoing case which commences at the time of the offense, if there's an accusation or an investigation, it pauses, it stops. If once the accusation or investigation ends, the statute of limitations then restarts. So it is our Cambodia's position that we believe that this would address the concern of the committee regarding statute of limitations. I'd like to move on to the next question regarding universal jurisdiction. And I believe that the question was with regard to jurisdiction, if there's a perpetrator who commits an act of enforced disappearance outside of Cambodia with no element that involves Cambodia, whether Cambodia recognizes jurisdiction over this perpetrator. For example, even if the victim is not Cambodian or if the offense itself was not committed in Cambodia. As we mentioned in our report and reply to the list of issues, Cambodia does not have any legal provision establishing competent authorities' jurisdiction when an alleged perpetrator commits an enforced disappearance abroad and is present in its territory, and when the alleged perpetrator is not extradited or surrendered to another state or to an international criminal tribunal, and when neither the alleged perpetrator nor the victims are Cambodian nationals. Nevertheless, we do want to highlight, particularly there is Article 17 of the Criminal Code of Cambodia that states that in criminal matters, Cambodian law is applicable to any person who in the territory of the Kingdom of Cambodia instigates or is an accomplice to a felony or misdemeanor committed abroad. If the two conditions are met, that the offense is punishable under both Cambodian law and foreign law, and the fact that the offense was committed is established by final judgment of a foreign court. While this is not exactly, we understand the elements of universal jurisdiction, we do believe that this does count or at least substantially covers alleged perpetrators who commit enforced disappearance and is in Cambodia's territory. I'd like to move on to the next question is with regard to the impartiality of the judiciary. Regarding this, I'd like to pass the floor to my colleague and Sasikurin to discuss.
Once again, I would like to thank His Excellency Head of Delegation. I think this question takes more time to explain, and also because it's very broad question in terms of impartiality and independence of judiciary. But I will try to elaborate and also to provide some useful information in terms of how Cambodian constitution guarantee the impartiality and independence of judiciary. So actually the impartiality and independence of judiciary do be guaranteed by the constitution of the Kingdom of Cambodia, Article 51 new paragraph 4 and Chapter 11 new judiciary powers from Article 128 new to Article 35 news. And the judiciary is independent from executive and legislative. And the Supreme, we have one independent organization presided over by the King, we call Supreme Council of Magistracy, is a constitutional mechanism to assure the independent and impartial of judiciary. And in such, we have a law on organization and functioning of the Supreme Council of Magistracy, dated in 16 July 2021, Article 31st. In terms of appointment, transfer, discharge, suspension, and removal of the title for all magistrates, including judge and prosecutor, and decision for disciplinary actions against magistrate. Cambodian has other legal framework for the good organization and functioning of judiciary, such as the law on organization of the court. Was adopted the same date, and the law on the statute of judge and prosecutor at the same date also. If there is a report of, normally if there is a report of corruption and lack of transparency, the issue will be responsible for initiate the case for the corruption, and perpetrators shall be responsible under law on the anti-corruption law. And Article 132 news of the Constitution, and the King is the guarantor of the independence of the judiciary. The law on organization and functioning of Supreme Council of Magistracy provide the legal framework and mechanism to ensure and assist the King to guarantee the independence of the judiciary in compliance with the Constitution. So, in order to highlight a bit detail about the Supreme Council of Magistracy, so I would like to, yes, only based on our Constitution, we have the King preside over the Supreme Council of Magistracy, and the composition of the Supreme Council of Magistracy under royal presidency of His Majesty the King. We have one Minister of Justice, two President of Supreme Court will be a member of that Supreme Council of Magistracy, Prosecutor General of Supreme Court, one member elected by the Senate with absolute majority of vote of the total Senate member, one member elected by the National Assembly with absolute majority of vote of the total of the member, among personality as a former judge or prosecutor or other high personality who has experience at least 15 years in legal and judicial field, and one member elected by the Constitutional Council with absolute majority of vote of the total member among personality as a former judge or prosecutor or other high personality who has experience at least 15 years in legal and judicial field. So when we have one member designated by the Minister of Justice among the other prosecutor, one member judge from High Court elected by all judge of the High Court, one member of prosecutor from the High Court from the Court of Ministry of Justice elected by all prosecutor of the High Court and Ministry of Justice. 10th, one member a judge from the Court of the First Instance elected by judge the Court of First Instance over the country. 11, one member of prosecutor from the Court of the First Instance elected by all prosecutor of the Court of First Instance over the country. All above member of the Supreme Council shall be appointed by royal decree. So this is, we have 13, 5 judge and 3 prosecutor. Regarding the case has been punished for the judge and prosecutor because of misconduct and the code of ethics and corruption issue. Thank you.
Thank you, Excellency Kirin. One of the other questions was with regard to the anti-corruption unit and its work. I would like to pass the floor to Excellency Rada on this. Thank you.
Thank you, Chair. Thank you, the head of delegation. Anti-Corruption Unit, the ACU is an independent body under the legal provision of Article 11, the establishment of the ACU of the anti-corruption law. It has the power to investigate, to arrest, and other special privilege provided by the ACL from Article 25 till Article 30. The president of the ACU has been accredited as the judicial police officer and also has a power as a prosecutor and investigating judge. Officials of the ACU are judicial police officer. The ACU, we combat the corruption through three-pronged approach policy. One, education, to cultivate mindset that had corruption. In short, people do not want to corrupt. Two, prevention, having mechanism in place to observe so that people cannot corrupt. Three, law enforcement, have a clear legal frameworks that define acts and punishment with zero tolerance so that people dare not to corrupt. Moreover, several policies have been taken, including legal frameworks, policies, and institutional policies. Legal framework policies, anti-corruption law was promulgated in 17 April 2010, which led to the establishment of the Anti-Corruption Unit, which has played an important role in fighting against corruption. Three measures have been undertaken to fight against corruption: education, prevention, and law enforcement, which public participation and support the international cooperation. Thank you, Mr. Head of Delegation.
Thank you very much, Excellency Radha. The next question I have here is with regard to the Royal Gendarmerie and whether they are competent to investigate. And the short answer is yes, because under Cambodia's Criminal Procedure Code, they are also recognized as judicial officers with the power to investigate crimes. So both the police and the Royal Gendarmerie, even though there are two entities, or two different units, but they both have powers to investigate crimes. Moving on to the next question here is with regard to the protection of witnesses and victims. Cambodia guarantees the protection of witnesses and victims under its criminal code, specifically Article 220, that states specifically that any intentional acts of violence shall be punished by imprisonment between 2 to 5 years if they are committed against a victim or a civil party, either to prevent him or her from reporting on an offense or seeking reparation for harm, against a witness to prevent him or her from testifying or at an investigation or judicial investigation or trial, against a victim or civil party who reported an offense or for seeking reparation, and against a witness for testifying at an investigation, judicial investigation, trial, or in the proceedings of other complaints. There was also a question regarding Cambodia's investigation process of how, under Cambodian law, the investigations are conducted. For this, I pass the floor to Excellency Gidding.
Thank you, His Excellency, Head of Delegate, for giving me the floor again. I think the process is very long. When there is a complaint, normally we have primary investigation made by the prosecutor office, and then after that, for the offense up to the criminal or it's a kind of misdemeanor or felony. For the crime, there is also open an investigation. I mean, the prosecutor will issue introductory submission. I mean, is a kind of requisitoire introductif en français, in French word, to the investigating judge to proceed for the investigation in order to find the guilty of the perpetrator. Normally, the investigating judge plays a crucial role in order to guarantee that the person who will charge have enough evidence to be charged. So normally, the investigating judge play a role as an, is an impartial role to conduct an investigation by collecting all evidence, discharge and charge. At the end of the conclusion, they will submit a closing order, ordonnance de clôture, to the trial to have a kind of trial on this. So this is just only a short brief of how the investigation process. And but I would like to highlight also, also we have cooperation from the police, judicial police in order to do investigation through the regulatory commission. Thank you.
Thank you, Mr. Sigurin. I see our time's up, and I apologize for us going over time. I know that we also have other questions that are remaining, but I pass the floor to Mr. Chair.
Thank you ever so much, Your Excellency. Obviously, you will have the opportunity to come back to a number of the items, but I'm grateful already for the many answers that you've provided. And now I'd like to pass the floor back to the rapporteur for the follow-up questions, and obviously potentially also to the other committee members, if they would like, they can raise their flags. So we have follow-up questions now for a total of 35 minutes.